Imagine that your company has a social media page where you publish marketing and other video content related to your company and its products. Well, today, unfortunately, you received something called a DMCA takedown notice from a social media site that hosts your company's webpage. This notice, which was sent on behalf of some entity you've never heard of, alleges that one of the marketing videos on your company's webpage infringes its copyright, and the entity demands that it be taken down. Or, to put the shoe on the other foot, imagine that you're a copyright holder and you find that your company's materials are being used online by another entity to promote its business without your permission. What should you do? Now today, I'm going to offer you guidance on how the DMCA, or Digital Millennium Copyright Act, operates and how savvy in-house counsel can help best guide their companies through the DMCA's various complexities so that you can answer questions like these. First, we'll examine what the DMCA and its safe harbor are providing by looking at an overview of the various types of copyright infringement liability, the treatment of new technologies and copyright liability prior to the DMCA, and the DMCA's thin blue line in balancing innovation on one hand and protecting enforcement rights on the other hand. Second, we'll assess how the DMCA and its notice and takedown regime work by looking at the mechanics of the regime, by identifying the particular challenges facing in-house counsel for rights holders, internet and online service providers, which are also known as ISPs or OSPs, and users of copyrighted content, and by examining how the extant jurisprudence, including the Second Circuit's YouTube case and the Ninth Circuit's recent Live Journal case, have highlighted these issues. In particular, we'll look at key matters that in-house counsel face when their company finds itself in the middle of a copyright battle, whether as a rights holder, an online service provider, or as a user of copyrighted content. Now let's begin with some background. The DMCA, or Digital Millennium Copyright Act, and its safe harbor provisions were passed in 1998, and they have 5 different sections. The relevant section we'll be discussing today is Title II, the Copyright Infringement Liability Limiting Act, OCCILA, which is codified in Section 512 of the Copyright Act. This is often known as the DMCA safe harbor, or more colloquially, as the YouTube exception. And it provides, under particular conditions, that internet service providers will be immunized from copyright infringement liability. Its provisions have fostered development of many Web 2.0 businesses, such as YouTube, Facebook, Pinterest, Twitter, and others, and it's literally prevented them from being sued out of existence. At the same time, however, Hollywood studios, record labels, book publishers, video game developers, photograph archives, and other content owners have long rued its existence. Now, there are several important points to note about Section 512. First, the immunization generally relates only to monetary damages, not injunctive relief. Secondly, the immunization applies only to copyright claims, not other types of intellectual property claims such as trademark or patent claims, or to any other cause of action. Significantly, the DMCA safe harbor is analogous to another piece of legislation which passed around the same time, the Communications Decency Act, which contained a safe harbor provision in Section 230, which protected online providers from defamation, negligence, discrimination, and other types of tort claims and state criminal violations that might stem from information residing on their networks from third parties. Critically, the CDA doesn't cover intellectual property claims. So in a sense, the DMCA safe harbor plugs one of those holes by providing protection on copyright claims that the CDA does not. Now, the DMCA does have other sections, but we're only going to focus on the safe harbor provisions. These provisions have become the DMCA's most controversial and most significant. Now, to understand the DMCA fully, it's important for us to first examine the world prior to the DMCA and how online copyright infringement was treated. What was Congress attempting to address with the DMCA? And with this in mind, we're going to begin by presenting a brief overview of the major theories of copyright infringement liability that have been recognized by courts and how these theories have been applied since the early days of the internet. First, there is direct infringement liability. This is the most common form of liability. To prove direct liability, one needs to show, as a plaintiff, that you own a copyright, that the defendant accessed your work, and that there's a substantial similarity between your work and the infringing work. However, courts have recognized also two other forms of liability. They are called secondary or indirect liability. Someone is liable under the first form of indirect liability, called contributory liability, if they have materially contributed to someone else's copyright infringement and they did so with knowledge. There is also a second form of indirect liability, vicarious liability, which is grounded in the idea of respondeat superior from tort law. A party is vicariously liable for someone else's infringement if they have the right and ability to control the infringer's actions, and they derive a financial benefit from these activities. In both cases of secondary liability, there needs to be some kind of underlying act of direct infringement by someone, and you then need to show a link between that someone and the defendant. Both of these types of indirect liability have been recognized by courts because courts deemed it would be unfair only to hold people directly liable for infringement. In fact, frequently there are entities and individuals who encourage others to infringe, and the courts have felt that they should face consequences for damages as well. Now, in the world before the DMCA, there were several important pieces of litigation regarding these theories of secondary liability, where rights holders sought to hold manufacturers of technology liable for uses the consumers may make of their products. The most famous case, one you've likely heard of, is Sony v. Universal, a 1984 Supreme Court decision involving the long-extinct Betamax home videocassette recording technology. By a single vote, a 5-4 decision, the Supreme Court rejected claims by the Hollywood studios that Sony should be liable for infringing actions of consumers using its VCR. In the process, the court carved out something called the Sony safe harbor that basically said that manufacturers of technologies capable of significant non-infringing uses, such as the Betamax, would be protected from and insulated from contributory liability. The metes and bounds of the Sony safe harbor were tested in two modern cases involving the internet, A&M Records v. Napster and MGM v. Grokster. In both of these cases, the courts limited the applicability of the Sony safe harbor. In Napster, of course, the court found that the early P2P file sharing software Napster had actual knowledge of the infringements occurring on its network, and that therefore the Sony safe harbor didn't apply. In other words, the Sony safe harbor does not cover defendants who have actual knowledge of specific instances of infringement on their network. And in MGM v. Grokster, the court found that the owners of Grokster, a P2P file sharing service that allowed mass infringement of copyrighted works, were basically inducing infringement, and that the Sony safe harbor could not protect them because of this induction activity. In other words, the defendants were aware of their business model and how it thrived on infringement, how they had held themselves out as a Napster substitute, and they had failed to develop filtering tools. As a result, the court found they had induced infringement on their network and would not enjoy the benefits of the Sony safe harbor. But despite the existence of the Sony safe harbor, early internet litigation created a very real threat of copyright liability for online service providers. In a 1993 case, Playboy Enterprises, a court issued a preliminary injunction against a bulletin board service operator because Playboy had photographs that had been uploaded on its system, despite the operator's lack of knowledge and despite the operator's removal of the photos when he actually did acquire knowledge. This set up the specter that online service providers might face liability for their actions of their users, even if they had no knowledge of them. A second case made this threat even more real. In Religious Technology Center v. Netcom, the Church of Scientology's copyright holder wing sued an internet service provider, Netcom, for allegedly infringing materials. The materials at issue were the works of L. Ron Hubbard, and they had been uploaded by Netcom users to a Usenet group. Although the court found that Netcom couldn't face vicarious liability for its users' actions, it left open the possibility that Netcom could face contributory liability for those very same actions. These two cases threatened to chill development of the internet, as the threat of online infringement liability for online service providers would stifle innovation and repress emerging technologies. These fears are magnified by several important factors. First, copyright infringement, particularly in a world of network computers that reside at everyone's fingertips, is ubiquitous and severe. While in the past one needed a printing press to infringe a copyright, we now all have printing presses at our desks in the form of computers, in our pockets in the form of smartphones, and around our hands in the form of smartwatches. Technology not only makes it very easy to violate the exclusive rights granted under Section 106 of the Copyright Act, but it has also improved the monitoring of infringement and made tracing of infringement activities even simpler. Finally, and perhaps most significantly, liability for copyright infringement can be severe. Direct infringement is a strict liability regime with absolutely no mens rea requirement for having damages assessed against you. On top of that, there is always the threat of statutory damages, which can amount up to $150,000 per willful act of infringement, regardless of actual harm. We now turn to the specifics and the 4 areas that protect online service providers, as codified in Sections 512A, B, C, and D of the Copyright Act. First, the Safe Harbor 512A provides protection for transitory digital network communications. This is basically conduit networks like Verizon and Comcast. Then there's 512B, an exemption for system caching on networks. This basically relates to activities that ISPs engage in to create copies of material for faster access. Third, there's an exemption under 512C for information residing on services or networks at the direction of users. This is what is known as user-generated content, and the safe harbor related there too. In other words, this is the big one. This is what allows Facebook, Tumblr, Pinterest, Twitter, and other Web 2.0 entities to survive. Finally, there's 512D, the Information Location Tools exemption, which basically creates a liability exemption for websites that are linking to infringing content. Our focus, not surprisingly, is going to be 512C, the user-generated content component. Now, the DMCA safe harbor has several major requirements before an online service provider can take advantage of it. And as in-house counsel for companies operating online, it is absolutely crucial to understand these requirements and ensure proper compliance. In particular, some of the requirements are very strictly enforced by courts, while others are less so. First, of course, the qualifying ISP must fit under one of these 4 buckets that I just mentioned. In other words, it must either be a transitory digital transmission network, it must perform system caching, it must engage in storage of information at the direction of a user, or it must provide information location tools. So in other words, the exemption only applies to ISPs performing one of these 4 functions for the performance of one of these functions. Second, and this is where the issue gets black and white, an online service provider absolutely must register a designated agent for receipt of takedown notices with the Copyright Office. To do so, you must file paperwork with the Copyright Office and pay a proper fee. Failure to do so results in a loss of your safe harbor. Period. No exceptions. Importantly, the Copyright Office recently changed its regulations, and as part of the updating of its system to make it more digitally friendly, it now requires registration of an agent once every 3 years. Again, failure to re-register one's agent every 3 years will result in a loss of the DMCA safe harbor. Third, an ISP must show that it has no actual knowledge of infringement of its network. Fourth, an ISP must show that it has no red flag knowledge of infringement on its network and that it has not acted with willful blindness towards infringement on its network. Fifth, any ISP that's taking advantage of 512C's safe harbor must also respond promptly to substantially proper DMCA takedown notices and must remove and disable the materials that are complained of. Expeditious removal of complained of materials is a requirement of the DMCA. Sixth, ISPs must also adopt a policy and reasonably implement that policy to terminate the accounts of repeat infringers. Seventh, ISPs cannot receive financial benefit and have the right and ability to control infringement. Eighth, ISPs must accommodate and not interfere with standard technical measures used by copyright holders to identify or protect their works. As we can see, there are a lot of hoops to jump through for an ISP to qualify for the safe harbor, so compliance can be a significant challenge for in-house counsel. On the other hand, for in-house counsel at content companies, despite its many frustrations, the safe harbor is indeterminate and can constantly be poked and prodded at for potential lines of attack on any number of these grounds. Now, to answer our question at the outset of this talk about how to handle a DMCA takedown notice, we need to examine the actual mechanics of the notice and takedown regime under the DMCA. As I mentioned before, the DMCA safe harbor gives copyright owners the ability to send takedown notices to ISPs infringing their content. For example, let's say you're a copyright holder and a video of yours is placed on YouTube by an unauthorized user. As the copyright owner, either you or your authorized agent can send a takedown notice to YouTube's registered agent to request removal of those materials. The notice must contain or substantially contain your signature, the identity of the allegedly infringing work, the identity of the allegedly infringed work, your contact information, a statement of good faith belief that the use of the material is not authorized, a statement that says that the material in the notice is accurate, and under penalty of perjury, that the claimant is authorized to act on behalf of the owner or an exclusive rights owner of the allegedly infringed materials. Now, if you do all of this, you have sent a proper takedown notice, and now an ISP is officially on notice about infringement on its network. To maintain its safe harbor, then, the ISP must then promptly remove or disable access to the identified materials or face infringement liability itself. So the initial burden of enforcement under the DMCA is placed squarely on content owners. They must scour the internet, find infringements, and serve takedown notices. But then the burden shifts upon the sending of takedown notices to ISPs, who must comply with the terms of the takedown notifications and remove materials. Upon receipt of a takedown notification, an ISP must take reasonable steps to notify whoever's materials are going to be removed that they received a takedown notice. Then, the recipient of the takedown notification, which could be, for example, a company with a YouTube channel or a business with a Facebook page, they then have the option of filing what's called a counter notification. A proper counter notification requires the recipient of a takedown notice to provide a statement, again made under penalty of perjury, that they have a good faith belief that the material was mistakenly taken down. In other words, it was perhaps fair use, or the sender of the takedown notice wasn't really a copyright holder or the owner of an exclusive right. The counter notification must also include a statement that the filer of the counter notification consents to jurisdiction in the federal court in which they live, or if they're not in the United States, to the federal court in which the ISP is found, should litigation result. Now, with receipt of a counter notification, an ISP then has not less than 10, but not more than 14 days to re-enable access to the infringing materials, unless the copyright holder files a federal copyright infringement lawsuit. So let's go back to the hypothetical situation we presented at the introduction, where your company receives a takedown notice. In assessing your responses, you'd want to consider the validity of the rights holder's claims. For instance, whether the sender of the takedown notice was actually a copyright holder or the owner of an enforceable exclusive right. Whether your work actually infringes on the copyright by reproducing, publicly distributing, publicly displaying, or publicly performing the copyright. Or whether your use could be excused by an affirmative defense, such as fair use, for example. If the use is likely to be infringing, you would likely accept the strike against your account, and then you would affirmatively conduct an audit on your page to ensure that there aren't other infringing materials up there that might result in liability or termination of your account. However, if there is reason to question the merits of the takedown notification, you should absolutely consider serving a counter notification, and perhaps even assessing whether it might be worth filing a declaratory relief suit in a favorable jurisdiction to deem your use non-infringing and to even seek damages under Section 512F of the DMCA, a provision we'll discuss shortly, if there is reason to think that the entity serving the takedown notice had subjective bad faith in doing so. So all told, the safe harbor attempts to balance technological innovation on one hand and intellectual property enforcement on the other hand. But in the process, it has faced significant criticism from many lawyers, companies, and individuals who deal with its various niceties. We're now going to examine some of the key problems and challenges that copyright holders, online service providers, and users of copyrighted content have experienced with the safe harbor regime. First, from the point of view of copyright holders and their in-house counsel, the DMCA system seems broken. Why? Because the massive burden of policing initially falls almost entirely on copyright holders. With companies with content libraries of materials that are regularly infringed online without permission, the requirements of the DMCA can be daunting and onerous. Some companies, in fact, have had to hire huge staffs of employees dedicated solely to the preparation of takedown notices and related follow-ups. On the other hand, the takedown notice regime is not even entirely effectual, even when the material is taken down. Takedown notices are easy for infringers to evade. A rights holder might send a takedown notice for a popular work that's infringed, and although it might be taken down, the same user can easily create a new account on the same service or even go to another service and infringe the work again. Or another user might infringe the work. In other words, copyright owners and their counsel face what is called a whack-a-mole problem. Just as one infringement is snuffed out, dozens more can easily spring up. Finally, various provisions of the DMCA safe harbor are extremely vague and are rife for exploitation by online service providers and users. As we noted earlier, Section 512 does not specify how quickly removal of materials must occur, what constitutes a repeat infringement, or even how service providers are to count strikes against an infringer. ISPs have been accused of playing games with these definitions. With respect to repeat infringers, some ISPs have implemented quite lax policies. Until recently, for example, Cox Communications had a 13 strikes policy. Not surprisingly, it resulted in only a handful of terminations for Cox's millions of users over the course of several years, and ultimately was struck as inadequate by the Fourth Circuit in BMG v. Cox. As an industry standard, many companies have adopted a 3-strike policy. In other words, if a user gets caught infringing 3 times, their account's terminated. But what counts as a strike varies. Some companies will say, for example, that multiple infringements on one DMCA takedown notice count as only 1 strike. Other companies will say that multiple DMCA takedown notices sent over the course of several days may only count as 1 strike. And finally, there's an ambiguity as to the amount of time a ISP has to respond to a takedown notice. 72 hours has become the industry standard, but there is no clear rule. Now, the most famous decision under the DMCA, the Second Circuit's holding in Viacom v. YouTube, illustrates some of these frustrations that rights holders have faced. In the case, of course, Viacom famously sued YouTube for over $1 billion, claiming effectively that YouTube was liable for the infringing activity on its network. The case was litigated up and down between the Southern District of New York and the Second Circuit for approximately 6 years, and ultimately, despite some threat of liability being faced by YouTube, YouTube settled the matter without any money exchanging hands at all. Although the Second Circuit actually reversed a grant of summary judgment for YouTube, it effectively eviscerated Viacom's theories of liability in most of the case. Most significantly, the court found that both the red flag knowledge and willful blindness prongs of the DMCA safe harbor actually required specific knowledge of specific acts of infringement, and not a generalized awareness of infringement. Thus, red flag knowledge only exists if, quote, the provider is subjectively aware of facts that would have made the specific infringement objectively obvious to a reasonable person. The recent Mavericks v. LiveJournal case out of the Ninth Circuit illustrates some of the critical challenges facing ISPs looking to preserve their safe harbor. Now, in the interest of full disclosure, my partners at 1LLP and I were lead counsel on the district court and appeal in the case. Deemed as the West Coast edition of Viacom v. Google by The Hollywood Reporter, the LiveJournal case addressed several key issues that raised concerns for online service providers. In the case, the Ninth Circuit reversed the grants of summary judgment on the safe harbor in favor of an online social networking site named LiveJournal, thereby resurrecting infringement claims brought by photography agency Mavericks. First, the holding suggested that LiveJournal's use of unpaid moderators to actively review user posts could defeat claims by the websites that infringing posts came, quote, at the direction of users, and could actually impute actual knowledge of infringement to LiveJournal so as to undermine its qualification for the safe harbor. Second, the Ninth Circuit held that the existence of watermarks on copyrighted content could provide a website with red flag knowledge that material might be infringing. Third, the court held that the extensive review and curation of posts on a website could mean that a website possesses the, quote, ability and right to control, unquote, activity on its network, and therefore could lose its safe harbor. In other words, to online service providers, a live journal decision puts them between a rock and a hard place. On one hand, they face a great deal of pressure, both to assuage rights holders and to improve their business models, to moderate and supervise their content more actively. On the other hand, though, the live journal precedent suggests that if they do so, that can actually lead to an increased rather than decreased chance of losing the safe harbor. Finally, we turn to issues facing users of copyrighted material. Now, this group doesn't just include individuals, but it also includes many companies. Companies such as YouTube channel operators that act as users of copyrighted materials. Users and their counsel should be aware of several significant problems under the DMCA and its takedown regime. First, as noted above, users may see materials removed online even if a takedown notice is flawed. Although users have an ability to file counter notification, some users are unaware of their counter notification rights, and ISPs are not under any obligation to notify users of this right. Moreover, a counter notification will only restore the materials after a period of delay, up to 2 weeks, meaning that their infringing materials may be, or the allegedly infringing materials, may be inaccessible for a particularly critical period of time. In fact, many political groups, from pro-choice and pro-life activists to various sides of the debate on gay marriage, have actually exploited this aspect of the DMCA to have the materials of their foes online removed in the lead up to elections. The victims of these takedown notices have had their materials restored, but only after the election, meaning they effectively had their speech muzzled at its most critical time. Secondly, for users of copyright content, fair use is a notoriously hazy issue, and statutory damages are quite high and liability can be absolutely massive. So many users fear that they do not have the monetary resources and appetite for risk to fight a takedown notification and to vindicate a fair use right. As a result, users will often just kowtow to a rights holder and not even bother with a notification, a counter notification, even if they believe what they've done is truly fair use. Now let's return to the hypothetical mentioned at the introduction. Except this time, let's say you represent the entity whose work has been infringed. In addition to weighing a possible infringement lawsuit right off the bat, you'd naturally consider serving a properly formatted takedown notice to the social media site that is hosting the infringing content so that you can get that content down. Be sure that you have a proper claim for copyright ownership, that the use is infringing, and that the use being made is unlikely to constitute fair use. If the social media website hasn't removed or disabled the content within 72 hours, be sure to follow up with them to confirm receipt of your notification and to remind them of their obligations to maintain their safe harbor. In the event that the infringing company responds with a counter notification, you'll then have to make a hard choice of either letting the material go back up online or filing suit in federal court in order to force the materials back down. Now notice that I emphasize the need to consider fair use and to assure that the materials are truly infringing before you send out a takedown notice. I did that because, quite importantly, there is a provision in the DMCA, Section 512F, that actually creates a private cause of action to deter overzealous enforcement efforts and disingenuous efforts by infringers to avoid takedown notifications. In short, Section 512F is meant to prevent DMCA abuse, either by rights holders or users of copyrighted content. The statute provides that any person who knowingly materially misrepresents that materials are or are not infringing shall be liable for any damages, including costs and fees, incurred by the misrepresentation. Now, in conclusion, as you can see, there are myriad challenges for in-house counsel for content owners, service providers, and users of copyrighted content in navigating the DMCA safe harbor. Despite these challenges, the advice I've shared with you today should assist you the next time your company is faced with a DMCA issue, and until Congress decides to provide more clarity or reform the current system. And while the case for reform has been made from parties on all sides of the equation, it is worth remembering an old saying from the dispute resolution world. According to that maxim, the best solution is one where all the parties are equally upset. Well, it certainly seems the DMCA has achieved that much, so perhaps no change is needed at all. Thank you very much.
Thanks for watching Lawdition. Continue watching programs that will challenge your thinking, while getting to know the best lawyers in every field as they share their insights, and all while satisfying your CLE requirements. When lawyers audition for new clients, everyone wins.